The First District Court of Appeal is now in session. All who have business before this court draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. Today we have 3 cases on the docket. We'll call the first case and likely take a short break after that. And follow with the last 2 cases. We'll proceed in the order of the docket. First case is Ameris Bank and Center State Bank versus Property Registration Champions and City of Jacksonville. Is the appellant ready to proceed?
Yes, Your Honor.
You may.
May it please the court, David Otero of Ackerman, on behalf of the appellants, Ameris and Center State Bank. Your Honors, this is a case, and a rather simple case actually, of statutory construction. All the parties agree that the appeal turns on whether section 655.017 of the Florida statutes preempts Jacksonville Code of Ordinances, Chapter 179. And in order to make that determination, Florida courts, as you know, follow the supremacy of text principle, and thus this case turns on the plain language of the statute. The standard of review in this appeal is de novo. I say it's a simple case because there really isn't that much material that we need to parse through to answer the question today. There isn't a long line of conflicting cases we need to resolve, and there's hardly any evidence in the record. All we need to do is look at 4 areas, I think, in order to resolve the appeal. The first is, what does the statute 655.017 preempt? The second is, what does the ordinance require? The third is, what guidance do we have from the evidence in the case law on whether the ordinance requires what the statute preempts? And the fourth area is to apply that guidance to the ordinance and the statute and come to a conclusion of whether the statute preempts the ordinance. And amplifying on that fourth area where we apply the requirements of the ordinance, the case law, and the evidence to the statute, the only way the appellees can prevail in this appeal is if the requirements of the ordinance do not in any way regulate financial activities or lending activities, or impose reporting requirements regarding financial services or lending practices, or impose other obligations regarding financial services or lending practices. If the ordinance does any of those 6 very broadly worded preempted things, the circuit court's order granting the city's motion for summary judgment must be overruled. And the
Counsel, are you challenging more than the imposition of the fee that the ordinance?
Pardon me, Your Honor?
Which aspects of the ordinance are you challenging? The entire thing?
The entire chapter, Your Honor. It works together to require the registration and inspection and maintenance, security, et cetera. So we're challenging the entire chapter. There's certain aspects of the chapter, of course, that there's definitional sections and things of that nature. The real substance is 104 to 110, and 104 has almost all of the substance. But we believe that it's most appropriate to declare the whole chapter invalid.
Well, which financial activity or lending practice of a bank is affected by having to register a potential default and paying a fee?
Well, Your Honor, this is all one transaction. When you come in to get a loan, and
it's not one transaction. I mean, once the loan is closed, you file a mortgage or record a mortgage, and that operates as a lien. And at the back end, when you seek to foreclose, that's a cause of action on essentially a contract or a financial instrument. But it's not a financial transaction. It's contractual, isn't it?
It's absolutely part of the entire lending relationship. If you came in to get a loan for your residence, we wouldn't give you a loan unless you gave us a mortgage and unless we had foreclosure rights. If you tried to negotiate in the documents that are all part of the loan that we don't have the right to foreclose, you wouldn't get a loan in the first place. So
well, are you contending that the ordinance affects your right to a cause of action for foreclosure?
No, Your Honor. I mean, certainly we can still can foreclose, but it certainly pertains to our rights with regard to our collateral, and it also pertains to our ability to foreclose. So really the question that you're getting at here is the wording of Section 1 here. Is this broad language? In other words, such that if there is a local regulation that affects our ability to get our collateral, to foreclose, it requires us to take action with regard to our lending practices, to pay fees, to hire property managers. Are those things closely related enough to what's prohibited in order to be barred? And we would say they certainly are, Your Honor. If you look at the language of subsection 1 here, it's very broad. I mean, they could have chosen very narrow language that it would be similar to what's argued in the briefs that just says that you're not things like it's preempted to require registration. But instead, it's very broad. It says anything that regulates financial or lending activities. And it also talks more about just regulation than regulation. It talks about things that don't seem as nearly as intrusive as regulation, like reporting. And there's even a catch-all category that talks about other obligations. So, Your Honor, this section, we believe, is very broadly worded and should be interpreted as that. And the reason that we think that it was intentionally worded like this was because the federal government and the state government are the ones that are entitled to regulate banking. This is entirely reserved under supremacy and state law rights. And local governments are not supposed to be in the business of regulating and imposing fees and registrations and requirements. It does amount to regulation, and that's why it's worded this broadly. And they're also...
If I could ask a couple of quick questions. I get that it has an economic impact on financial institutions and others. Utilizing your theory of the plain language and the supremacy of the text, if the statute said that any ordinance and so forth that causes adverse economic impacts on financial or lending activities, you probably prevail, because these requirements do impose costs and burdens as to perhaps what the banks and other affected institutions do. But it says only that what's preempted are those things that regulate. So it's a two-part question. Isn't the statute narrower than you're saying because it doesn't include economic impact? And secondly, what type of financial regulations or lending regulations are there on the books? Because I know that the banks are highly regulated, right? I mean, what is there on the books in Florida that would be similar to what the city has done here?
Well, first of all, focusing on the word regulates, note that it prohibits more than just regulation. It also prohibits reporting requirements. It also prohibits, and it has a catch-all that says other obligations. So that suggests that this is meant to be very broad. And obviously, reporting, for example, reporting requirements with regard to financial services, that wouldn't have a huge economic impact on a bank to have to do reporting, right, of any type. But it would be very similar, if not exact, to what this particular statute has. But that's not what the regulation or what the statute is trying to bar here. What it's saying is, look, the federal government and the state governments are the ones that are allowed to regulate banking business. And anything that's at all related to banking business is going to be barred. The things that aren't barred are the things that a municipality does routinely with regard to all of its citizens, like zoning and property taxes and noise ordinances and fire codes and all those things. Those are the things that fall into the category of things that aren't imposed here. But the federal, for example, one of these banks is a national bank, center bank, and one of these banks is a state bank, Ameris. So the federal bank, center state bank, is regulated by the Fed, and it's primarily regulated by the Office of the OCC. And then Ameris Bank, even though it's a state bank, is also regulated by the FDIC. And so the area of banking, this key area for the operation of commerce in this country, has not been left to the local governments. This statute is just reinforcing the general principles of supremacy and state rights, that this regulation is all done at the federal and state level. And that's why
what type the entities that you mentioned, the Comptroller of the United States and state agencies that regulate the state banks. What type of regulations, if you can give an example, do they have that control how a bank forecloses on a mortgage?
You mean that would be identical to
no, I mean,
exactly what's here?
Your answer to a prior question of mine is that, oh yeah, no, foreclosure of mortgages at the back end, once a borrower is in default, that's also financial activity, financial services or lending practices. So presumably these agencies and entities that regulate banks would have controls and regulations over how mortgages are foreclosed, if that were the case. So I'm curious, what are some examples of rules in place to control how banks foreclose on their mortgages?
Well, the OCC and on the federal level and the OFR have a plethora of regulatory requirements with regard to what's fair lending and fair practices.
But that's at the front end. That's when they're initiating the loan or closing on the loan. I'm saying once there's a default, are there controls in place that regulate how banks file a foreclosure suit in state court to foreclose on a mortgage?
Well, I'm certain that if a bank was engaging in unfair practices, if they were improperly foreclosing when they weren't supposed to, that would be something that the offices would entertain as being improper behavior. I mean, I don't know a citation to a particular regulation that mirrors what this one exactly intends to do. But it is absolutely certain that this is within I don't think it really makes a difference, because what the rule is that the federal government and the state government are the ones that regulate banking businesses, and local governments are not allowed to regulate banking business.
But that's not what the statute says. It doesn't say that local governments cannot regulate banking entities. It says that they cannot enact or enforce ordinances that regulate them, their activities, or specifically financial or lending activities, or imposing obligations on financial services or lending practices. So it's not directed at the banks, it's directed at specific types of activity.
Correct. I said banking business. I mean, the business of banks, not banks in particular. So I was using a general term to describe the business of a bank, which is a bank takes deposits, a bank makes loans. When a bank makes a loan, it takes collateral. It has a right to foreclose. Anything that regulates that bank's right to take that bank's rights in connection with the loan, obviously in a broad reading of what that statute says, which is what the chapter says, we're supposed to read this broadly, that it's supposed to be read broadly to interpret, to match what it is that they're trying to do. And what they're trying to do is say, localities, you cannot regulate banks when they're doing banking business. Yes, you can regulate banks when they're acting like regular citizens. So yes, there's.
But isn't that what they're doing here, counsel? Isn't, I mean, I know in your brief, you mentioned that City of Jacksonville already has an ordinance about dilapidated properties. So it's somewhat duplicative, but isn't the ordinance just saying to banks, like it might say to a single homeowner, you have to take care of your property? It just so happens that banks have a lot of properties in default. I'm sure we've all seen homes during the last 15 or since the 2008 crisis. Homes sit dilapidated year after year after year after year that the banks own. And so the ordinance, and I know your argument is the wisdom of the ordinance is not at issue, but isn't the ordinance just essentially regulating property maintenance?
Well, first of all, a lot of this regulation, or a lot of this ordinance deals with periods when the banks are not the owner.
I understand that. So let's just focus on when you are the owner. We'll get to your argument about, well, they're making us regulate, or they're making us respond on properties we don't own yet. That's a separate argument. Let's talk about properties you do own. You foreclose on a house and that house sits empty. The rats move in, the house falls apart, the grass is 4 feet high, and this local government say, banks, you own this property and you have to take care of it. Now, I know there's your argument that we've already got that covered in your general maintenance, but the fact that it's duplicative doesn't make it preempted, right?
No, it doesn't. But the fact that if it isn't duplicative, it's a special rule with regard to the banks, and it's moving into what's uniquely bank business.
But when I looked at your affidavits, the affidavits, they seem very conclusory to me. I say in my affidavit that this interferes with my banking and lending business. How does it interfere with your financial and lending activities?
Well, it certainly creates a bunch of requirements and expenses that don't exist otherwise. There's no duty that we'd have a property manager, for example. There's no duty that we'd have to come in before ownership and do a bunch of these items. I'll grant to you, Your Honor, that it appears less intrusive with regard to properties that are owned, because you're right that once a property is owned, we do have to comply with anything that has to do with ownership. But anything that's outside of what would be required of any regular owner, that also falls into the category of regulation of uniquely banking business.
Oh, so, how do you make that distinction? How do you make the distinction between pre-foreclosure and post-foreclosure? So a minute before foreclosure, it's financial or banking activity, and a minute after foreclosure or after the sale, and the bank is the owner, that's no longer bank activity or banking practices or financial services?
No, but you're moving into an area which I think Judge Thomas was pointing out, where there's existing regulation with regard to all kinds of owners. It's not unique to this particular situation. So I would still argue that the whole ordinance is still infringing on banking business. But I would also say that the argument is better with regard to properties that that they own than it is in the prior position, because in the prior position, there's no argument that I see, Your Honor.
All right, well, time flies when you're having fun, and you only have 45 seconds left. I'll increase it to a minute and a half for your rebuttal and try to add approximately 45 seconds to the appellee's time. I assume you're preserving the rest of your time for rebuttal.
Thank you, Your Honor. Yes.
Thank you. The appellee may proceed.
Thank you, Your Honor. Jason Teal with the Office of General Counsel representing the city of Jacksonville. And we have with us Mr. Jason Gonzalez, who is representing ProChamps. And if we could, Your Honor, we'll take the first 10 minutes, and then Mr. Gonzalez will have the second 10 minutes. We'd like to split up our time that way.
All right, well, you actually have 10 minutes and 22.5 seconds. So.
Even better. Thank you, Your Honor. So, Your Honor, we agree, the city agrees with Mr. Otero in that this is a fairly straightforward statutory interpretation case. This case does boil down to the pure legal question of what do the terms financial and lending mean within the context of Section 655.017. And I wanted to point out that this is a case of first impression in terms of, at least at the District Court of Appeal level. There is a prior circuit court case that's cited in the city's brief, the Advance America case versus City of Jacksonville, which dealt with this very issue in terms of preemption of a local ordinance. And in that one, the trial court, in I guess my opinion, correctly ruled that the city's attempt to try and place a ceiling on payday loan companies and interest rates is something that directly falls within the purview of 655.017. Now, where the outer angle of that lies, or the outer extreme of that lies, it has not been defined by the legislature. Now, the appellants want the court to define it in the most broadest sense possible, in that if it prohibits, the statute would prohibit regulations that infringe on any incidental power of any banks or a bank to do banking activities. Now, that's not what the legislature said. What the legislature used was the words regulating financial and lending activities and reporting requirements and other obligations regarding financial services or lending practices. Now, what the trial court in this case focused on was, in particular, the terminology that was used, which is to regulate those activities. The prohibited and preempted ordinances have to regulate financial and lending activities. And so, or it has to be a regulation regarding, financial and lending activities, or that has to be specifically about lending activities. That's not what our ordinance does here. And it's important, I think, is in terms of the court understanding exactly what the city's doing here, to look at it in the context of this is not an attempt to infringe on the bank's ability to engage in lending and financial activities. How the ordinance came to be, and the court already has asked a number of questions of Mr. Otero on this point, is that in response to the 2008-2009 recession, there were hundreds, or if not thousands, of foreclosure actions that were pending in the city of Jacksonville. And in large part, those were predicated on risky loans, or loans that in essence were had interest rates that weren't sustainable, for dollars amount that weren't sustainable, that sort of thing. And the foreclosure cases would languish in our courts literally for years. And what ended up happening in that time were the properties were left unmaintained. They were falling into disrepair. They were blight. There was criminal activities that were going on these properties.
Counsel,
Yes,
I don't think anybody's questioning the wisdom of the ordinance. I don't think any reasonable person could object to the city's attempt to prevent blight, but why direct it at the banks? I mean, you have an ordinance apparently on blight, right?
We do, Your Honor.
So if I live in Jacksonville and have a house where I was born and raised, and I have a house there and I allow it to become an eyesore and don't take care of my property, you have an ordinance that addresses that, right?
We do have an ordinance that addresses that in terms of interacting with the property owner. In terms of if you've got a property owner that is not maintaining their property, then what our property safety code does is it allows the city to either place a lien on the property, which will.
So you could do that. You could do that with all of the bank's properties, right?
We could do that with all of the bank's properties, but the problem with it, Your Honor, is that most of these properties we were dealing with were vacant or abandoned properties, meaning there's nobody there to correct the violation.
But you could do that to a property owner who had a vacant house, right?
We could do that, Your Honor. What we could do is we could expend taxpayer dollars to go out and mow the grass, board up a building, demolish a structure, those kinds of things. But all that would result in is a lien on the property. And the city would be out of pocket. Now, remember, this is during times when it wasn't just a foreclosure crisis, it was a recession. And property values in Jacksonville, the ad valorem tax that we were bringing in were down. And rather than expend city resources to go out in hundreds of, if not thousands of cases to correct these violations, then the city was left in a position with trying to find somebody who was responsible for it. The city attempted to reach out to the banks in these situations, Your Honor, and that's key about the foreclosure registry. It's not just to place a requirement on the banks. It's actually to have the banks tell us who's responsible for this. The city attempted to reach out. We knew about the loans. We knew about the foreclosures. We attempted to reach out to the banks to try and get somebody to step up to maintain the property, and we got no response. So
let's try it this way, because this is, at least in my view, a very close question of statutory interpretation. You can put a lien on homeowner X's property that is not maintaining the property, right?
Correct.
Any homeowner.
Yes, sir.
And so if the bank is not the homeowner because they haven't foreclosed, that lien would be placed against a homeowner, who may be at risk, but he hasn't defaulted yet. So he's still the owner of record, even though he's the mortgagor, right?
Correct, Your Honor.
Okay. So aren't you really arguing for an ordinance that specifically targets banks' business model by saying, well, we're going to hold you accountable above and beyond homeowner X by making you list all your properties in default that you don't even own yet. We're going to make you pay a fee, although I'm not clear that $15,000 worth was paid. And we're going to regulate the way you foreclose on properties by ensuring that you take care of those properties. That's what the ordinance does, right?
The ordinance does do that, Your Honor. What the ordinance does is it relies upon the contractual relationship between the bank and the property owner in order to develop a legal responsibility. The banks have the right to, and they have a property interest based upon that contract. And what the foreclosure registry does is it puts a requirement on the banks that is already included within that foreclosure within that mortgage contract. To require them to prevent waste is a common contractual requirement.
But that's already in their business model, right? I mean, a bank's business model is going to be, now we all know, I don't think I'm revealing any secrets here, that some banks have allowed properties to remain vacant and to suffer disrepair, shall we say. But that's part of their business model, right? Whether to ensure that properties that they either own or will soon own based on a year's worth of missed payments, that it's in their interest to take care of that property.
We would hope that would be part of their business model, but unfortunately, that's not what we were observing. What we were observing was the former, which is that there are banks that are out there that were not maintaining these properties. And the city council did not enter into this regulation lightly. It responded to a growing and what appeared to be a long-standing problem, which is that these properties were tied up in foreclosure cases for years at a time and nobody was maintaining them. And so that may have been part of a normal business model, but the environment that was in existence in 2010, when the city council adopted this, was not conducive to that. And so what the legislation does is creates an administrative requirement on these banks to have to account for what's in their inventory. And the legislation was changed in 2018. I want to clarify something on that point, which it's only triggered when the banks file a foreclosure action. That's when it starts. So prior to filing the foreclosure action, none of these requirements are on the banks. They only kick in once it's a defined term in the ordinance now under default. It means when you file your foreclosure case. And the issue is that the legislation, the statute, doesn't have a broad blanket, open-ended, you can't touch any banks at all. What it specifically is limited to is only those activities that are directly related to financial, to lending and financial services.
Would you agree the ordinance increases the cost of the bank's collateral properties?
I would agree, Your Honor, but I think that the city has different things in place that also do that, such as stormwater fees and solid waste fees, and different types of those activities that place responsibility on people who own or have a financial interest in property.
Counsel, is the ordinance limited to banks, or does it apply to individual lenders as well?
It applies to anybody that has a mortgage on a property, whether that's a bank, whether that's some other type of financial institution, whether that's an individual that is self-financed a loan on a piece of property. So it would apply to anybody that has that contractual relationship through mortgagee, mortgagor. And so with that, I see that my time is up. So if unless you have further questions for me, I will turn over the remainder of our time to Mr. Gonzalez.
May it please the court, Jason Gonzalez, representing the appellee ProChamps. My client is one of the companies that administers this program under the ordinance. Your Honor, it's going back to a question that Judge Makar had asked of appellant's counsel about the significance of the word regulate in this state statutory express preemption clause. This has been a common thing in the trial court, in the appellant's briefing and argument, and in the briefing here and today, where the appellants are brushing over that word, or they're substituting the word regulate for effect or impact to the lending practices or lending activity or financial activity. And that's just not what the text says. The legislature did not write an express preemption of any local ordinance that in any way impacts lending activity or lending practices. Regulate means control. That's the definition of regulate. And a legal regulation is to control, and in this sentence, control lending activity, which your honors know what that is. You don't even need to look at a dictionary definition. Lending activity is when you provide money for someone's use in return for an agreement to pay it back at a later date. This ordinance does not control that lending process. This ordinance just says, tell us if this property is vacant. And if it is, tell us who's going to be responsible for taking care of it and inspecting it. That's not in any way a control of the lending process or financial activity, which is defined as a debt or equity transaction that uses money or some money equivalent in order to accomplish some economic goal. This
so can I ask you a question on that? And there's another part to it. There's regulate's not the only verb in the statute. There's also imposing other obligations on financial services or lending practices. But first, let me ask: could a municipality or local government impose a lawsuit tax? So suits filed within, let's say, Duval County. Could the city of Jacksonville impose a tax or fee on anyone that files a lawsuit for, let's say, I don't know, foreclosure actions, or pick a subject matter. But could a local government do that constitutionally?
Well, I'm not sure if the Florida Constitution provisions on restrictions on what local government, the parameters of a permissible local government taxation would or would not allow that. I probably have to take a look at it. But with respect to, what they are trying to argue here, these appellants, is that these mortgages are something that is affected by the ordinance. It's somehow impacted. And because mortgage liens are something that the banks use in their business, that somehow the preemption applies. And it doesn't. There's no express preemption of that. And the analogy I used with the trial court, it kind of goes to a little bit analogous to a lawsuit tax. But if you had, in my practice, something integral to my practice of law is paper. We use a ton of paper. We put our work product onto it, and we then dispose of a lot of paper. And if a local government came in and said to us, we passed a recycling ordinance, and we're going to put reporting requirements on how much paper you use and how you dispose of it, they would not be regulating the practice of law. Or if a fire marshal told us how much paper we could store. That's an asset integral to what we do. And if a local government does something that impacts it, it's not regulation of the practice of law any more than a local government that comes in and says, we need to know if these properties are vacant and who's responsible for taking care of them, even though those mortgages may be integral to some of the business of this bank. It's still not a regulation, a control of the lending activity or lending practices. And Judge Tannenbaum, on the reporting requirements, again, it's reporting, it preempts reporting of the lending activities, practices, and the financial practices of the bank. That's what the express preemption is. Again, if you look at the types of reporting and regulations in Chapter 655 all the way to 667 of the state statutes, just peruse those, and you can get a good look at all types of financial and lending activity regulations. This ordinance does not in any way try to do the sorts of things in those financial regs. It's not concerning itself with how these banks go about their lending practices. It doesn't even ask in the registration, it doesn't even demand that the banks identify who their borrower is. How on earth could we be regulating lending practices if we don't? The ordinance is not asking for any reporting of interest rates or debt to equity ratios or who is in default, how many properties, how much have you loaned, and certainly doesn't seek to control those activities.
So do you disagree with opposing counsel's position that lending practices extend beyond the closing of the loan?
I think, Your Honor, you made a good point that there does seem to be a distinction between the lending front half of that transaction, and then there's collection and mortgage foreclosure on the back half. I spent 15 years handling lending and collections and mortgage foreclosure for a bank based here in Tallahassee. And the back half of that transaction is very different. So I think your question raises a very good point. But even if it was part of, if the mortgage foreclosure process is part of lending practices, we are not controlling how they do that. And I told the trial court judge at the summary judgment hearing that the night before the hearing, I took the ordinance one more time and scoured it. And you can do this word by word by word, sentence by sentence. And I could not find a single thing in there that would have been an obstacle to anything I did as a bank attorney to go through that lending and then collection and foreclosure process. There isn't. And in the case law that they've cited, the Masoni case where Chief Justice Kennedy described what is a real instance of kind of the test of a real preempted provision is if it presents an irreconcilable conflict with the state law such that it stands as an obstacle to the accomplishment of its full purpose. And that's what the U.S. Supreme Court also said in the Barnett Bank case. This ordinance doesn't do that. I couldn't find anything that it would stop what I was doing in either lending practices or financial activity. And if you look at those affidavits that one of your honors brought up, the affidavits that were filed in the trial court, they are just a list of complaints about the burden and expense of complying with this ordinance. They're not a legal argument for how this ordinance is expressly preempted. And in our constitutional system, I'm not aware of any circumstance where a fact affidavit can change the text of an ordinance or a statute. We can put in 10 million.
I have a question. Did they allege that they had expended over $15,000 in fees? Did the banks satisfy the jurisdictional requirement of the circuit court?
I'm not sure that they did. I think that may be in the affidavits were not specific. They gave a couple of anecdotal instances. But,
I saw some sums that didn't come close to 15,000.
Right. What's in the affidavits certainly did not in the complaint. If there are no further questions, Your Honor.
Counsel, if we have a little bit, just with a few extra seconds, let me follow up on that. So the complaint alleged that this was a controversy with over $15,000, and pro-champs admitted that for jurisdictional purposes. Now, assume for a moment that you can't stipulate the jurisdiction. Is there any further obligation at the back end, like in summary judgment, does someone bear a burden of showing that amount in controversy, if it's not otherwise readily apparent where that amount in controversy came from? Or was it just, as a threshold matter, just an effort to get into circuit court to litigate this preemption question?
I think they have a responsibility to allege it, and if we were to, if we were not to stipulate to that, they would need to prove it. We went into a summary judgment hearing, and I think that I don't believe they met a burden on that, and it's a very good jurisdictional point that you've raised.
All right. Thank you, counsel for appellees. We'll add another 43 seconds to appellant's time. So I think he's over 2 minutes now for his rebuttal, or close to it.
Yeah, you're on mute. Still on mute. Still on mute.
Apologize.
That's okay.
Thank you very much for restoring my time for user error. As Judge Tannenbaum pointed out, there are three parts to this local regulation preemption statute, which, by the way, is the title of it. This is not a situation where we're trying to engineer a preemption and saying that this statute acts as a preemption. That's why it's here in the first place. But if you look at the second and the third requirements, the second one is just reporting regarding financial services or lending practices. And the third is other obligations regarding financial services or lending practices. And we would certainly say that the collateral and the foreclosure is part of our lending practice. And regulation is not required in order for us to prevail, just reporting requirements, which is beyond dispute, as well as other obligations. As far as the
ask you a quick question, I got limited time. Where in the record can we look to see in an affidavit or whatever it might be, the facts you've alleged to support these other obligations regarding financial services or lending practices? Is it a particular affidavit?
Well, if you look at the ordinance itself, and I would encourage you to do exactly as counsel said, look at the 2018 ordinance, go through it, especially section 104, one by one, and you'll see that there's other obligations in there like security, maintenance, hiring a property manager, etc.
Yeah, but my question is, how do we link those to what the statute focuses on, which is financial services or lending practices? Does an affidavit say that subsection 104 sub C imposes a burden on our financial services or lending practice and specify what that practice is?
Well, it says making of loans secured by real estate mortgages, foreclosure, acquisition of banks' collateral, holding and management of real property obtained, and subsequent sale. That's what the affidavit
Right,
said.
I see that, right, but that's it.
Okay. Payment of, in the paper exhibit, hypothetical, paper is not part of law. Collateral in foreclosure is part of lending. That's the difference. The testimony is based on the experience of these bankers saying that there's an effect based on this ordinance. And we also cited case law that showed that these banks have primary powers and incidental powers that include what's regulated and what's required to be reported here. And I apologize for going over time. Thank you, Your Honors.
Now I had user error. I apologize. Thank you both for your arguments. I will proceed to the next case.
Thank you.
Well, it looks like everyone's here, so we'll proceed to the next case. Gregory Brown, Santa Rosa County Property Appraiser versus City of Gulf Breeze. We've scheduled 20 minutes per side, or 15 minutes per side, excuse me. Counsel for appellant may proceed.
Thank you, Your Honor. And my name is Lauren Levy, and I represent Greg Brown, who's the Santa Rosa County Property Appraiser. And if I could, before I begin, can I please reserve 3 minutes for rebuttal, sir?
Yes, thank you.
Thank you, Your Honor. Your Honor, this case is an ad valorem tax case, and it involves the taxable status of certain golf course facilities that are owned by the City of Gulf Breeze. But
Mr. Levy, I'm sorry to interrupt you so quickly, but you both wrote excellent briefs on this case, and it's a fascinating issue. One argument your opponent makes is that under your argument, the city can, or a city can never outsource to a private entity to manage its property. That's a correct statement with your argument, right? A for-profit entity.
I believe with this caveat, Your Honor, if a city allows a private entity to use its property in a for-profit proprietary manner, then yes, the Constitution requires taxation.
So anytime a for-profit organization, a management company, I mean, this is a fairly routine business model in the private sector and becoming more and more routine. So under your argument, a city can never outsource to a for-profit. I'm not sure a management company could be not for profit. They may try, I guess, down the road, but it could never outsource to a for-profit company to operate a swimming pool, a golf course, a marina, to save taxpayer dollars.
Yes, sir. They're not allowed to do that under the Constitution. The Constitution requires taxation of those facilities under those circumstances, Your Honor.
Okay.
And if I could follow up with that, Your Honor, we've got a long line of these cases, and we tried to put all of those in our brief. The legislature, the Supreme Court has said several times, would not have any authority to attempt to adopt a statute that would allow an exemption for city-owned property when used by a private party, if you would, Your Honor. And we certainly would suggest that if the legislature could not do that, then certainly private parties may not contractually do that. We think it's very clear that if the city had leased the golf course facilities to Integrity Golf, they would be taxable. And the city cannot avoid that obligation via the mechanism of a management agreement. And Your Honor,
Counsel, I thought every case that's addressed this issue said that they can. What case?
I'm sorry.
What I thought every case that I've read says that they can in Florida. What case says that they can't? In other words, hey, if the city wants to outsource the mowing of the shoulders along right-of-ways to a for-profit lawn mowing company or maintenance company, why can't they do that? I mean, where does it say they can't do that?
Judge Makar, the city certainly can do that. They can hire independent contractors to maintain the facilities. What they can't do is provide a possessory interest, if you would, in those facilities to a private contractor to use the facilities to generate business profits.
Well, you say possessory interest. I mean, they don't. In this case, they don't own or control the property, do they? The management company.
I believe the management company certainly has a possessory interest in these golf course facilities, Your Honor. They are the only entity that's allowed to run the golf course facilities and generate a profit therefrom.
Does that give them a legal interest in the land?
Yes, sir. They have an interest in the land. They have an agreement that says for 7 years, subject to 2 5-year renewals, they will be the only entity that is allowed to use the golf course facilities, which is the course, the bar, the restaurant, pro shop, to generate business profits. Yes, sir, Your Honor.
Well, I guess I'm reading a different order because the trial judge's order seemed to suggest that the city had the sole right to control the property.
The city, and we're kind of into the argument, Your Honor, about is this a lease or a management agreement?
Right.
But the city certainly retained, I would suggest, obligations typical of any landlord, that they have the right to control the use of the property in a certain respect.
So your argument is that the trial court erred in construing the management agreement, and it should be a lease.
Certainly, Your Honor, that's our second argument there. Or I guess another way you could look at it would be that it would be unnecessary to reach the argument of does it matter whether the use under the constitutional provision is pursuant to a lease versus a management agreement if you concluded that the agreement in this instance was in fact a lease. And
What do you say to the argument of the city that, well, look at all the prerogatives we retained, signage. I guess they have control over what kind of golf balls the management company can sell, fees to charge to the public. You know, all these elements of control. Would you concede that it's, regarding Judge Makar's question, there are a lot of elements of control here retained by the city?
Yes, Your Honor, I certainly would concede that the city has retained some level of control that is a bit further than what a typical landlord would retain. But in sum and substance, what is going on here? Integrity Golf is paying rent to the city for the right to use the golf course facilities for a 7-year term with 2 5-year extensions to generate business profits for itself. And that
And the
requires
minimum rent-
ad valorem taxation, Your Honor.
And the minimum rent is 100,000? As I
The
read
minimum rent is 100,000. And then if there are certain gross revenue thresholds met, there will be additional amounts owed under the contractual obligation. So in effect, the city is sharing in the profits being generated by this property.
Counsel,
And
let
Your
me,
Honor, if I could just,
if I could, that touches on a point I wanted to ask you about. So you conceded in your brief that, that it was okay when the city was operating the golf course. That was exempt activity. And I believe you made that concession despite the fact that clearly the city had every intent of turning a profit. They just admitted that they did a terrible job at it and weren't turning a profit and were running a loss. And that's why they ultimately went with Integrity Golf. So is it okay for a city to run a golf course that it owns for its own profit, so to speak?
Your Honor, I believe that's been answered in the affirmative. The Treasure Coast Marina case would have addressed that. A case that was cited in Treasure Coast Marina, the Islamorada case, specifically addressed that and said there's nothing wrong with the city making profits when it is using the marina itself. But when it allows use by another for-profit entity to generate business profits, a separate test for exemption is applicable. And under the Constitution, we would suggest taxation is required.
So it would be okay then, it would remain exempt if the city hired a consultant to help it be more profitable in running the golf course. Do you agree with that?
I think the city could hire a consultant to give it advice on how it may better operate the facility. But when the city turns the facility over to a third party for-profit contractor, let's call them a contractor, and tells that contractor, you are allowed to run the golf course and generate business profits from that entity is using government property for proprietary purposes, and taxation is required, Your Honor. The
Let me ask you,
constitutional
counsel. So
yes, sir.
Let's say a clever management company says, well, we decided that we are a nonprofit management company. We're going to pay all our chief executives $1 million a year, and we're going to ensure that we never show a profit. We'll pay the city the minimum $100,000 lease, but please be on notice that we will not accept filthy lucre, and we are a nonprofit management company. What would your argument be there?
That the sum and substance of what that entity was doing was for profit and for profit making purposes, Your Honor. You know, we're throughout taxation, we're always looking for what is truly happening here. We look at the form and not the substance. And so our argument on the use of this property here really begins and ends with the plain language of the Constitution, which says all property owned by a municipality and used exclusively by it. And here factually, we have to acknowledge that this property is not used exclusively by the city.
But it's for a municipal, it's for a municipal purpose. You have to concede that.
No, sir. Once and city of Gainesville,
golf courses aren't for municipal purposes.
They are a permissible municipal purpose when the city is exclusively using the property, Your Honor. That's what the city of Gainesville case says. When the city turns around and allows a for-profit entity to use its property to generate business profits, that's a proprietary use and it is required to be taxed. The city of Gainesville gave us an excellent discussion of why that is.
Is the same case with a sewage treatment plant? A sewage treatment plant? Same
yes, sir. I would submit that it would be the case. We've not had that situation happen in the case law, but it would be the case if you're allowing a for-profit entity to use city property, it should be taxable. If I could go back, for example, the Page versus Fernandina Beach case, this court has observed that when the city owns and uses it exclusively, that marina is exempt. But when the city leases that property out to a for-profit entity.
Well, you just used the word lease. There's not
yes, sir.
But there's not a lease here. You're arguing there is, but the trial court found otherwise.
Well, the trial court found otherwise, and that's a legal determination. And Your Honor, I would hope that the court would look at the agreement closely and see that it is a what's described as a management agreement masquerading as a lease. And Your Honor, if I could suggest, to the extent there were any ambiguity or reasonable doubt as to how we should construe this agreement, it must be construed in favor of taxation and against exemption. But the City of Gainesville case, the Treasure Coast Marina case that I handled, those two cases very clearly say when the city is owning and using the property exclusively by itself, that definition of municipal purposes would include a golf course, Your Honor. But when the city allows a private for-profit entity to use that same facility, regardless of the terms of the agreement, Your Honor, it's required to be taxable. The Florida Constitution doesn't say anything about a lease. There's no use in there about a lease. And that's where we believe the trial court really went wrong. It's very clear that that provision is self-executing. And the trial court.
So is your concern how Integrity splits the fee? Like if instead the city paid Integrity every month to provide a service like running this golf course, and any profit, I mean, any money made at the golf course was turned over to the city, would you be taking the same position that this was not exempt property?
I think that's a much different position, Your Honor. Yes, sir. Now that also goes into, that cuts both ways. Is this really a lease or a management agreement? It goes to that argument, because typically a management agreement would involve the payment of a fee to a certain entity.
Well, it sounds like you're just taking the approach that whatever the reality is on the ground, whatever the label is, doesn't really matter as much as what's actually going on. What type of activity is actually happening there?
I would certainly agree, Your Honor, and that's a bedrock principle of ad valorem tax. In fact, all tax matters is substance over form. You have to look at what is really going on out there on the ground, and move forward through that. Your Honor, I want to be sure that I talk about the City of Sebring case in 2001 out of the Florida Supreme Court. That case involved kind of the second visit of the City of Sebring Raceway to the Florida Supreme Court. In 1994, Florida Supreme Court had said that the property that was leased to a private for-profit entity was subject to taxation. The legislature then attempted to pass a statute to basically overturn that decision. And the wording of the statute was that the use of city-owned property, and I'm paraphrasing here, by any licensee, lessee, or management company, and then it described a list of the purposes, would be deemed municipal purposes. The Florida Supreme Court held that entire provision unconstitutional. If the city's argument is correct here, Your Honor, that the lease is the sole thing that makes a difference, the Florida Supreme Court would not have been necessary for them to hold the entire statute unconstitutional. They simply would have said, well, to the extent a lease is involved, the statute is unconstitutional, but we can preserve the constitutionality when we're talking about licensees or management companies. The court didn't do that. It also went on, Your Honor, and bookended.
Counsel, I think you've exceeded your time.
Oh,
So
I'm very sorry.
that's okay.
I
I'll let you
It is a
go.
little small.
I'll let you go.
Well, I was going to say that the Supreme Court bookended its argument with the other provision in the relating to bonds that talk about leases or contracts. Thank you very much.
Thank you, counsel. So I'd ask the clerk to award another minute 24 or so to the appellee's time. Actually make it 2:24, and I'll give the appellant another minute to conclude, to rebuttal.
Thank you.
So 2:24 in addition to appellee, and 1 more minute for appellant. Let's give the clerk a minute to figure that out. There we go. Appellee, thank you, Madam Clerk. Appellee may proceed.
Thank you, Your Honor. Good afternoon, and may it please the court, Mr. Levy. My name is Todd Harris, and along with my co-counsel, Ed Fleming, I have the privilege of representing the city of Gulf Breeze in this matter. And of course, Your Honor, we believe the trial court correctly found that the agreement between the city and Integrity was in both substance and form a management agreement and not a lease. And in doing so, it applied the basic common law tenets of what does and does not constitute a leasehold interest. The fundamental characteristic of a lease is that it conveys the exclusive right of possession and control over the premises to a tenant during the life of the lease. Gravy Callahan, a case we cited from the Florida Supreme Court, says, quote, during the life of a lease, the lessee holds an outstanding leasehold estate in the premises, which for all practical purposes is equivalent to absolute ownership. The estate of the lessor during such time is limited to his reversionary interest, which ripens into perfect title at the expiration of the lease, close quote. Put another way, Your Honor, the essence of a lease is that during the life of a lease, the lessee looks like the owner. In this case, the trial court correctly concluded by looking at the plain language of the management agreement and the undisputed record evidence that Integrity did not look like the owner. And that's because the management agreement was specific about the rights that it was and was not granting to the management company. And of course, we've given a litany of those examples in our briefs, and I'll touch on just a few of them here.
Counsel, if I could ask a question, is there any evidence that the private company is making lease payments for use of the facilities, or is it just a management fee?
None. There's no evidence that it's making lease payments, Your Honor. The management agreement sets up the pay structure so that it is so that the way that the management company is paid is that it retains any profits that it might take in as it's essentially its payment of its fee for the services being provided to the city.
Okay, and as I understand, the management agreement doesn't have any right of control over the property by the management company. It just has the right to use and access.
Yeah, in fact, it specifically grants the right of access to the management company to the parking lot and the facilities for purposes of providing services to the city. And the city specifically retains control to do anything on the property that it otherwise has the right to do, and it retains the right to access the property at any time for any purpose.
And the golf course is open to the public, correct?
Yes, sir, it is. And that's mandated by the management agreement, and the city establishes the days and hours that the golf course has to be open.
Okay, because it looked as if the property or the golf course was surrounded by private properties, like private residential properties. But the fact of the matter is the property itself is city owned, and the bordering adjacent properties are all privately owned.
You're correct, Your Honor.
Okay, thank you.
Counsel, what would you call the $100,000 or the 5 or 7% of gross that Integrity pays to the city? You said it's not rent, so what is it?
It is the amount that the management company pays for the right to essentially be on the property and provide services to the city, Your Honor.
Gosh, that sounds a lot like what a tenant does when they pay rent to a landlord, is the right to be in that apartment. So why is that different?
Actually, Your Honor, and we cited the court to in the matter of Dabin Corporation, which is a case out of a federal court, which is persuasive authority on the issue, in which a fee was also paid as essentially a license fee that granted the owner and operator of a children's store to operate within a retail space. He paid a percentage of his revenues to the owner of the facility for the right to operate there. The owner of the facility later argued that it was a lease payment, In applying common law principles, the same common law principles that are at issue here, the court said, no, that is not a lease payment or a rent payment. That doesn't decide whether an agreement is or is not a lease agreement. What decides whether an agreement is a lease is the substance of the possessory right that's granted. It has to grant exclusive possession or control. So regardless of what the payment arrangement might be, or the payment structure of any agreement, that is not determinative of whether or not it is a lease or is not a lease.
Well, that would be true if lease was mentioned in the Constitution, which it's not. So I'm curious why I would be looking to common law principles to figure out whether what the city is actually doing here fits within the exemption or outside the exemption. If the reality is, whether it's a lease or a license, and I'm not sure how characterizing as a license helps you, because either way, what you said is that Integrity is paying the city for the right to be there on the property and run a business and presumably make some money off of it. So how does that differ from, how is that not a governmental proprietary function, whether you call it a lease, a license, or something else? If the activity is achieving a government purpose or being on government property and providing a proprietary function, why that doesn't put it outside the exemption?
Well, a couple of things, Your Honor. First of all, the governmental versus governmental proprietary test only applies where there is a leasehold interest involved. And
well, why would, I mean, I know that the cases talk about it in that concept, but what is the origin of that distinction? Like, is there something in the Constitution that says that we can't consider that paradigm in the context of the broader language of the Constitution?
Well, that's what the Florida Supreme Court has said, Your Honor, in Treasure Coast Marina, and in cases that the court relied upon there as to the test that we're to look to when we're deciding under Article 7, Section 3, whether a municipal exemption is appropriate or not appropriate. And in Treasure Coast Marina, the Florida Supreme Court said if it is owned by the municipality, if it is open to the public, and if it's operated by the municipality for a municipal purpose, then it is entitled to an exemption under Article 7, Section 3. And that's exactly what the trial court found in this case, Your Honor, and we think correctly found in this case.
Well, based on what facts specifically indicate that the city was operating this golf course? Because I think the facts are that it was Integrity's employees that are occupying the place and running it on a daily basis. It is Integrity that's responsible for the property taxes, by the way. It is Integrity that's responsible for the costs. It's Integrity that's responsible for the capital improvements. So what part of what facts indicate that it's actually the city running this golf course?
Well, Your Honor,
take it outside of that paradigm that, you know, in Treasure Coast and Sebring and the others.
The facts on the ground and the unrebutted testimony before the trial court, for example, from Ron Pulley, who was director of Parks and Recreation, was that the only thing that changed after Integrity was hired as the management company was that instead of being on the property every day, he was there 2 to 3 times a week supervising Integrity, checking on the golf course operations, and that he met with them every week.
Right. What he said is he was operating as a contract manager instead.
That's correct. He was overseeing, of course, as the city, overseeing the city's agent. So instead of the city having W-2 employees on site working, it had an independent contractor on site working, being overseen by the city's employees. So the city, not only did it have its director of Parks and Recreation that was weekly, multiple times a week, overseeing the operation, but of course, under the substance of the management agreement, it had control over the rules that govern the facility. For example, the city approved the kind of clothing that could be worn at the city. It even controlled how loud the employees could listen to their radios on site. It affected what could be sold, or controlled what could be sold at the facility. It controlled, most importantly, because the most important thing about this property to the city was its use as an effluent field to spray brown water. It could use the facility at any time, day or night, and to spray any amount of effluent on the golf course. And that was the city's right, regardless of what else was going on the golf course. So it was, Your Honor, and in almost every way, except no longer using W-2 employees, it was operating the golf course, both in the form and substance of the management agreement and in the on-the-ground activities.
So, Counsel, is it your position that Treasure Coast and the cases that preceded it, Sebring 1 and 2, that categorically the paradigm set out there about government versus government proprietary functions, that categorically does not apply to, say, like a license or anything besides a lease?
I believe that that's the Sebring governmental versus governmental proprietary test, Your Honor, does not apply. And I think Treasure Coast makes this clear, does not apply. Whereas in this case, the municipality owns and operates a facility that's open to the public for a municipal purpose. So
change the facts in Sebring, or pick a case. Change the facts such that it's no longer a lease, but on the title at the top, this is an exclusive license. Suddenly, and everything else stays the same. The licensee gets exclusive use to use the property to turn a profit. That suddenly falls outside the paradigm, and that would be exempt activity. Is that what you're saying?
Well, Your Honor, looking at the substance of the agreement, I think if you start getting to an exclusive use and possession and control of the property, regardless of what you call it, it could be deemed a leasehold interest, which would—
No, I said just exclusive license. So the city would still own the property. It provides an exclusive license. It means that no one besides integrity can come on that property and use it to run proprietary activities, aside from, of course, the city. But you're saying that this whole analysis that is talked about in Treasure Coast and the other cases goes out the window, and it's categorically exempt because the city did not lease the property to someone else.
I am saying that in the scenario that you mentioned, Your Honor, where the municipality continues to have the right to own and operate the property, even though it may have an outside entity, in this case like Integrity, that has the right to manage the property for the city, it does not fall into Sebring paradigm.
Well, it seems like we have semantics here. A typical management company gets paid a fee to do a service. It's not what we have here. We have an entity that gets to come on the property exclusively for 5, 7, or whatever years and do a lot more. They can run the property, they can turn a profit, they can do capital improvements, they have to pay the taxes, they have to pay the costs of the incurred in the business, and they have to pay the city $100,000 or 5 to 7% of gross every year for the opportunity to do that. So I'm having a hard time understanding how this is purely just management of the city's golf operation.
Well, Your Honor, I think that the important analysis of that is not whether it looks exactly like a traditional management agreement, but whether or not it in fact grants a leasehold interest in the property to the management company. And I believe the trial court was correct in finding that it does not grant such an interest. And therefore we have to look to what does Treasure Coast Marina, for example, tell us about how the property should then be treated under the facts that were before the trial court. And we believe that it has met the Treasure Coast test for determining a municipal exemption.
Right. Thank you.
Thank you, Your Honor. I appreciate the questions.
Counsel, is there an analogy between, say McDonald's owns the real property? That's typically the way it is, and a franchisee comes in and just operates it. McDonald's owns the property, has great control over the franchisee, signage, what you can sell. Is there an analogy there? Is that sort of what you're arguing?
Well, the analogy on the control issue, I think, is correct, except this isn't even, I think, more, there's even more control being exercised in this case because of the degree of right that the city has to be on the property at any time for any reason, to do anything that it would otherwise have the right to do if the management company wasn't there. And that especially comes into play with the ability to control the property for purposes of disposing of its effluent whenever and however it needs to do that.
Well, let me ask you this. The management company can't do anything on its own as to the property. It can't change it. It can't, right? Okay, it has to get city approval. And then there's many aspects of what it does do in terms of managing that the city controls as well. Yeah, the merchandise that's sold, the advertising, the signage, employee discounts, point of sale equipment, it goes on and on. And it says there's rules and regulations as well that the city has imposed upon it. So where does the management company actually have any discretionary authority over the control and use of the property?
It's not much, Your Honor. I mean, there are some, obviously, in the day-to-day operations of, and I think some of the substance that was before the trial court, and that's in the record before this court, is they made decisions about when to water, normally when to water the golf course. They were the ones that handled and sort of established some of the methods for, how we handled, receipt of the greens fees, all those kinds of things. But even the point of sale, even the cash register, for example, had to be approved by the city. You couldn't give an employee discount. Integrity couldn't give an employee discount without reporting that to the city. So the depth of control that the city had over supervising the operations was extensive, Your Honor. And so with that, I want to return, I guess, back to Treasure Coast Marina for just a minute and point out that Treasure Coast Marina cites with approval this court's decision in Zingali versus Crossings at Fleming Island. And in that particular case, the district, which was treated as a municipality for tax purposes at that particular time under Florida law, used a management company, East West Partners, I believe was the name of the management company, to operate its golf course. This court approved the municipal exemption that had been given there, finding that appropriate, in spite of the fact that the municipal district used a management company to assist it in operating the property. And in Treasure Coast Marina, the Florida Supreme Court noted with approval this court's analysis of how the municipal exemption was handled in that case. The four questions, Your Honor, established by the Florida Supreme Court: is it owned by the municipality? The answer to that is yes. In this case, is it open to the public? Undisputed that that's the case. Is it operated by the municipality? We submit to you that it is. Does it serve a traditional municipal function? I don't think that's disputed anymore either. And that's the appropriate case. That's the appropriate test when no lease is involved, and no lease is involved in this manner. And we ask that you affirm the trial court's judgment in this case. Thank you, Your Honor. I believe my time is up.
Thank you, counsel. Rebuttal.
Yes, Your Honor. And Treasure Coast Marina very clearly said that that rule only applied when the property was being used exclusively by the city. And in these facts, it's very clear that the property is not being used exclusively by the city. Judge Tannenbaum, you asked.
What do you say to counsel's position that that the whole paradigm goes out the window if this is not a lease? So I guess if it were a license or an exclusive license, we wouldn't be applying that test at all. I read Sebring 1 and 2 as and Treasure Coast as being a little bit broader and talking about uses and how it's being used. What do you say to counsel's argument on that?
He's absolutely wrong, Your Honor. The Florida Supreme Court has repeatedly said we're going to rely upon the function by utilization case or test. You had asked, what if the facts were different in any of these cases? Well, let's take the Sebring case. What if the use was pursuant to a management agreement? Would the Supreme Court have held the statute unconstitutional that said the use by a lessee, licensee, or management company could constitute a municipal purpose? The court held that unconstitutional. So if it were a management agreement in that case, we would be in the same place, which this case is not just an esoteric exercise and governmental exemptions. This is important. If there were such a loophole, every city would simply structure its agreement with any private entity as anything but a lease
Counsel,
and
I
avoid the
thank you for your
Constitution.
argument.
Thank you very
I'm going to
much.
try and be fair to both sides on the timing. Thank you both for your arguments and excellent briefs. And with that, the court will be in a short recess before the final case.
Thank you, Your Honor.
Thank you both. We will now proceed to the third case on the docket, Russell versus Summit Care. Is the appellate ready to proceed?
Yes, Your Honor.
You may.
Your Honor, before I begin my remarks, I'd ask that the court withhold 2 minutes to allow for rebuttal at the end of my argument. So I'll speak for 18 minutes and then tender the floor to my colleague, Ms. Edelstein.
All right.
Thank you, Your Honor. May it please the court and counsel, Your Honor, my name is J. Rod Cameron. I represent Christy Russell versus Summit Care, a workers' compensation case in which the accident occurred back in August of 2018 when Ms. Russell was assisting a disabled patient in the convalescence home that she was a certified nursing assistant. As a result of the injury, she suffered low back injury, which required her to seek medical treatment and subsequently to receive medical restrictions that prevented her from doing her regular job as a certified nursing assistant. The case moved forward through November of 2018. My client continued to receive regular medical care, but in November 5th of 2018, Ms. Russell did resign from the employer, the injuring employer, Summit Care, and moved to a new employer, which was the Escambia County EMS, working in a code position that didn't require any physical actions on her part. At that point in time, she continued to earn wages that were equal to, or at least exceeded the 80% that was required by Florida statute 440.15.4, and she wasn't eligible for temporary partial disability benefits. However, towards the end of January of 2019, that position, because Escambia County changed some computer programs, she was let go from that position and then was eligible for temporary partial disability benefits. At that
Counsel,
point,
on that point, why would you say that, or which fact or piece of evidence are you relying on for that assertion that she became eligible once she left the EMS coding position?
Because at that point, Your Honor, her wages fell below the 80% threshold required by the statute.
Right, but where's the connection between that and her injury?
The connection because she continued to be under medical restrictions that would not allow her to do her previous job as a certified nursing assistant. She was under continuous medical restrictions.
Your argument is when she provided the temporary disability form to the employer was obligated to reassert its offer of comparable employment, right?
That's correct, Your Honor. Once she completed the forms, that's laid out in the Republic Waste versus East Bay Sanitation case, that the onus is on the injured employee to submit a form before they can even become entitled to the temporary partial disability benefit. Once they do that, then the carrier has 7 days to evaluate whether or not they've met the statutory threshold. And at that point, the employer carrier has options. They either offer her additional suitable employment, they procure, that is, they find her another job within her medical restrictions, or they pay her temporary partial disability benefits. And none of those were done at that point in time, which we had 3 periods of temporary partial disability eligibility that was stipulated to at trial. And that first TPD period continued until February.
So it seems to me the whole case, and I neglect to mention that no one is obligated to use their entire 20 minutes. But that this whole case centers around whether the employer carrier is required to make a phone call and say, hey, we got your form and your old job is available or another similar job, or we're going to contact someone who can give you employment. The employer carrier's argument seems to me to be, no, it's your obligation to contact us and say, I lost my position at Escambia County and I'm ready, willing, and able to accept suitable employment.
You're correct, Your Honor. And that's what the form does. The form puts both the employer and the carrier on notice that this individual who continues to have medical restrictions is now seeking temporary partial disability benefits, and it gives the employer carrier those 3 options. That is, offer a job, procure a job, or pay the benefits. And that's what the purpose of the form is. That's what the purpose of the administrative code is to allow the carrier who acts on behalf of the employer at that point to then.
Even though you've made some evidentiary arguments about the record keeping and the predicate for the argument about whether that the employer carrier, offered her a job, it all comes down to that form, doesn't it?
I wouldn't say that it all comes down to the form, Judge Thomas. What I would say is that the form puts the secondary.
I understand. But here, the entire argument is that once they received that form, they had to do one of those three options.
That's correct, Your Honor. That's correct. And that's based upon what this court has decided in both the Moore case as well as in the NJM case, is that once they are put on notice, then the employer has specific actions that it has to take.
So it doesn't really matter. So your argument about the predicate, as I recall, it doesn't really matter whether the employer carrier's representative said, oh, we had plenty of work, we could have given her work. It was their obligation to contact your client and offer her the job.
Your Honor, that with regards to that, what I argued in my final reply brief was that I'm asking for kind of a bright line rule there. The court put forward in NJM a three-pronged test, but that three-pronged test has no statements with regards to the offer of employment, although it's implied because an injured individual could not refuse a job unless they received an offer. It's not stated in there, and I believe the way the judge of compensation claims examined this evidence and analyzed it was that the offer from when she was still with the injured employer continues throughout time. There's never a break in that offer's relevance all the way through the period of time, and that instead the onus is on the injured employee to do more. And I don't think that's what this court said in Moore. I don't think that's what this court said in NJM. The court indicated in all those cases had significant evidence that after the employee was injured and placed on restrictions, that the employer made efforts to offer work within their suitable employment within their medical restrictions. And that evidence is completely absent in this case, other than the point in time after she was injured from August until November, where the employer accommodated her at Sandy Ridge Rehab Center.
Well, counsel, on the flip side, it sounds like by your position, your position is attempting to convert an employer carrier to an unemployment compensation provider, because she had back at her original employer, she had replacement employment. She was working full time, commensurate with her restrictions, and having nothing to do with the injury, she chose to leave because of this pre-planned. She was taking classes for coding, and the opportunity arose, and she took it. She left and had nothing to do with her injury. She goes to the next employer. She works there for a couple months, and then she loses her job. And now she comes back to the employer. And again, she loses her job, not having anything to do with her injury. And then she attempts to find employment online through a variety of ways, any employment, as she says. And then she comes to her original employer and says, hey, I guess effectively you're saying that she should get her old job back as part of her. Suddenly she's eligible for TPD because she's now unemployed because her other employment didn't work out. What's your response to? I've said a lot, but what am I missing, or how am I? I'm sure that's not what you're arguing, but help me understand how this is not unemployment compensation that you're arguing.
Sure. It's not unemployment, Your Honor. And the difference is this fact is even after she had lost her job at Escambia EMS, the claimant continued to suffer medical restrictions that prevented her from doing her old job.
Essentially, your argument here is, look, My client mitigated her damages. She moved on, did not require TPD while she was working for Escambia. She saved the employer money because she obtained equivalent employment. But once she submitted that form, until she reaches maximum medical improvement, I'm going to try to say a sentence without 3 acronyms in it. Until she reaches maximum medical improvement, the employer is on the hook under the statute, right?
That's correct, Your Honor, with the caveat that that loss of employment can still be examined by the judge of compensation claims to determine if she was at fault. At that point in time, there is a different consideration for the judge in that she was employed, not creating liability for the employer. Now she's lost a job that was basically saving the employer money from any temporary benefits while they're still paying medicals. But was that loss of the job her fault? There was no finding of that in our particular case, and nor were there actions on the part of the claimant that would have led the court to say, no, you unjustifiably refused continued employment.
So that's your limitation on the rule. I understand your argument. I mean, she could lose the right to temporary benefits if she had just up and quit the Escambia County job. Is that right?
Or been fired for cause because she stole paper or a stapler or a pen or, walked in late drunk or something like that. I mean, we've had plenty of those cases.
So she's now at maximum medical improvement. You're asking for 3 periods, right?
That's correct, Your Honor. Actually, she wasn't at maximum medical improvement at the time of the trial because she had just underwent lumbar surgery. But on this date, today, she is at maximum medical improvement. Yes, sir. She is. But back to my argument, the employer carrier's defense in this was the affirmative defense of refusal to accept suitable employment. The problem with that argument is the refusal has to be accompanied by an offer. The case law is clear that once there's been a severing of the employment relationship between the injured employer and the employee, then any continuing offer or accommodation of employment ends there, and we're into a new period of entitlement for temporary partial disabilities. That's why our argument at trial was that there were actually 3 different periods, because there was a short period of time in January through February where she was unemployed. Then she regained employment working as a babysitter, but it was for a reduced amount that met the requirements of 445.15. And then there was a final period of time up and through the trial where she was searching for a job but had not found work, that she had a 0 income stream that also made her allow for entitlement to the temporary partial disability benefit.
Well, counsel, how many job offers did she receive that she turned down because of her medical restrictions?
The record shows none, Your Honor. Any job that she was offered, she accepted during these 3 periods of time. How does that not hurt your argument or just undercut it completely? Because your response to another one of my questions was she's on TPD because she was still on medical restrictions and was not earning income because she was out of work again. But it seems to me that doesn't she bear the burden of proving that there's a connection between her lack of work and the injury, her medical condition following from the injury? That is her primary burden of proof, and her testimony was accepted by the judge of compensation claims that there continued to be a causal connection between the injury and her inability to work at the time of trial. That was the initial finding that the judge of compensation claims made before he applied the affirmative defense that was put forth by the employer carrier. I agree that is a necessary factor and element in determining whether or not she is entitled to these benefits. And the court found that she had that causal connection remained and that she was entitled to temporary partial disability benefits, but for the affirmative defense that was put forward by the employer carrier.
The affirmative defense is you resigned, you moved on, you didn't contact us. We weren't required to renew an offer.
That's correct. That was their argument, Judge. And I'll put it like this: if there was any evidence in the record of an offer,
Yeah, I don't think there is.
I
I
think
think we have
would.
your argument. I'm gonna let you say 5 minutes for rebuttal.
Okay, sir. Thank you, Your Honor.
Appellee may proceed.
Thank you, Your Honor. Lara Edelstein on behalf of the appellee. I think that the argument is not necessarily that it's our burden to provide her with a job once she sent in some forms. She didn't send in forms providing notice to the employer or the carrier that she had lost her job. The last that the employer carrier knew, in November, she resigned her job unrelated to her injury, and she took a position that she was earning above the 80% mark, so she was not entitled to TPD through January when she resigned from her EMS position. Again, that resignation was unrelated to the work injury, and it was not reported to the carrier that she was unemployed or that she was underemployed when she was working as a babysitter. It was her requirement to, or she was required to submit forms or contact the carrier, which she did not do. The offer that was on the table was made to her when she was first injured in August. She accepted the light duty position. She worked full-time in the light duty position.
I don't think there's any dispute about those facts, but
That's correct.
Counsel for appellant says, okay, we sent in the TPD request form. Is that something that you dispute?
Yes, Your Honor, that's not in the record. She submitted an earnings report for November and for December, and by her own testimony, she said she didn't receive any more earnings reports until June. So when she lost her job in January, she didn't submit an earnings report again until June. So the carrier was not on notice that she had lost her job in January. And again, it goes back to the affirmative defense of voluntary limitation of income. As Judge Tannenbaum was saying, because there's no connection between her resignation and her work injury, the employer has no further duty once she resigned to provide her with suitable work or procure her a new job somewhere else or to provide her with temporary benefits.
Even if you were on notice?
That's correct, Your
I assume
Honor.
the facts are, we're going to get back to appellant's counsel about exactly how his client notified you that she was entitled to temporary partial disability payments. But your argument is, even if she had, say in February, said, well, it didn't work out at Escambia County. Here's my form. I want TPD, excuse me. I'm going to try and avoid the acronyms. Temporary partial disability payments. Your client could have said, no, you resigned. We gave you equivalent employment. We have no further obligation.
That's our position, Your Honor, exactly. And the only testimony that his client had during the trial was that she made some phone calls to the carrier that went unreturned. But we don't have any documentation regarding that. She could have contacted them in writing. We don't have any documentation of that. Only testimony that she allegedly called the carrier and left messages.
Well, counsel, your client didn't cross appeal. So what should we do with the JCC's final order that makes a determination that there's a causal connection between her injury and her later failure to earn wages? Even if, and I'll say, even if there's like zero evidence to support that connection other than the employer's original acceptance of compensability.
Well, we would stipulate that she was there was compensability, but right. Once she resigned, any duty that the employer had was over. At this point, Your Honor, I guess this court could find, because the TPD benefits were properly denied, that the court, that the JCC
An alternative basis for affirming. Is what
Correct. Right.
Right.
Found the right decision, but based on the wrong reason.
Got it.
And so, again, I hate to repeat myself, but under the MJM Electric case, the 3 prongs have been met. We did offer her suitable employment. It was refused once she resigned, and her refusal was unjustified because even though she was leaving originally for a job that she thought she had enough income to not have to have the benefits, it was her decision to leave, and any unemployment or lack of payment at the 80% rate was basically her decision. It was her choice, and she left, and she never called the carrier and said, hey, can I get my old job back? So, there's really not much else to say other than that the MJM Electric case proves that we established our affirmative defense, that she voluntarily limited her income, and that the employer is not required to reach out to her and seek her out and invite her to come back at any time.
Could we not read subsections 6 and 7 together? If we read them together, it suggests that subsection 6 would apply while she's still employed with the, I guess, the injuring employer. And subsection 7 suggests that something else happens after the employee leaves employment. So why did your client assert subsection 6 as an affirmative defense here? I guess, do you disagree with that assessment? That is it your position that subsection 6 can apply even after the employee leaves employment?
I believe it can, Your Honor. The case law holds that the voluntary limitation of income can be analyzed or analogous to a refusal of employment, and that's why the defense was the voluntary limitation of income rather than the employee leaving the employment. And even if subsection 7 did apply, it talks about the claimant having to provide affidavits regarding her new employment, which there's no evidence that was done in this case as well. So, under subsection 6, it says that the employee shall not be entitled to any compensation at any time during the continuance of such refusal, unless the refusal is justifiable. And so I guess the at any time would be, post resignation in this situation.
Right, but then your argument then comes back around to, I guess, to suggest that if you're relying on subsection 6, that does make your client a perpetual insurer of unemployment. So if you're counting refusal at any time to include leaving the employment, if she chooses after she leaves your client's employ, and she wants to come back at some point, doesn't that require the employer to allow her to come back? And that seems to cut against your larger position.
Well, those aren't the facts here, though, because she never contacted the carrier or the employer and said she wanted her job back. So, that's assuming, facts that don't apply here. The JCC specifically found that all of her post-resignation actions constituted an unjustifiable refusal, because we knew from day one that she started her job with my client that she was taking courses to change careers. So she chose to leave to change careers. And then when she lost that job, she still didn't want to be a certified nursing assistant. The testimony was that even though that was what her job was for 20 years, she didn't want to go back into that field, and she didn't apply to be in that field. And so that was another, the JCC found that was still a refusal of the job with the carrier. And then she took a babysitting job, which has nothing to do with her background, her medical background. and, chose to limit her income to $250 a week for, several months. And, when that ended, also because unrelated to her injury, she was left unemployed, and she still didn't contact the carrier or the employer to say, hey, I'm unemployed, I need suitable employment. So all of those actions taken together, the JCC correctly found that all of those constituted a refusal, an unjustified refusal of suitable employment. So, it's our position. Again, once she resigned, we didn't have any responsibility to reach out to her and provide her with suitable employment.
If she had contacted you on February 18th, 2019 and said, I'd like to be considered to be employed again in my old job, what would happen then?
Well, the administrator of the employer testified at the hearing that the employment was available and that they could have accommodated her restrictions at any time. But, again, that just didn't happen here. So
Right. But I'm just saying, if it had happened, would she have gotten that position back?
Well, then she would have been, working in suitable employment, and benefits wouldn't be necessary. So, she didn't resign. There was no bad blood.
So the answer is yes, she would have gotten it back, but she wouldn't have gotten TBD.
That's my understanding, that she would be invited, not invited back, but accepted, to come back. There was no reason she wasn't terminated for cause or disciplined in any way. She wasn't, she didn't resign. Her termination from or separation from the employment wasn't based on any disciplinary actions or anything like that. So there would be no reason why they wouldn't have allowed her to come back if she had called and asked.
Because I thought the theory of your side was essentially that her offer of employment was continuing. There's a continuing availability of the position, but she didn't avail herself of it.
Correct. It was continuously available. The administrator testified that the position was available for her at any time from the date that she resigned in November through the December 2019 date when she had surgery, which was the time frame that is being requested.
But the only notice she had was at the very outset. There was no ongoing, continual exchange of information or communication with her about it, other than what the other side says, which is some notice that was provided.
That's correct, Your Honor. There was no other communication. Again, once she voluntarily resigned her position, it's our position that we had no ongoing duty to reach out to her to provide her with a job. So, the appellant is arguing that, that the employer had some extra duty to contact her, reach out to her, provide her with a job. Again, we had no notice until June of 2019. And at that point, she had already been either unemployed or not making the amount of money for about 5 or 6 months at that point. But, the other issue is, why should she benefit from the fact that she resigned her position? The employer provided her with suitable employment pursuant to her work restrictions, and that's all they were required to do. And she refused. She turned it down. After she was there for a few months, she turned it down to go and take basically a desk job. And so, once she did that, again, we had no responsibility to reach out to her, no duty to provide her with additional employment, especially because the connection between the resignation and the work injury was not there. If there aren't any other questions,
Counsel, I had a question. So, we went back and was trying to skim it. I don't recall you arguing in the answer brief, tipsy coaching doctrine type of stuff as an alternative ground of affirming the fact that there wasn't competent substantial evidence to support the JCC's determination that there was a link between the original injury and her later loss of wages. Could we still apply the tipsy coachman doctrine or affirm on an alternative basis if you haven't argued it?
I think that this court has the ability to do that, even though it wasn't raised in the arguments. I think that, you know, again, it was the claimant's burden to establish that connection, and if it's not there and it's not in the record, and this court reviews the record for competent substantial evidence and finds none, then I think that this court can make that finding.
All right.
If there are no other questions, I will ask that the court affirm the decision denying the TPD benefits. Thank you.
Thank you, counsel. Rebuttal?
Thank you, Your Honor. Just to correct a couple of the factual statements that were made by counsel, there actually was testimony from the claimant at trial that she received temporary disability forms in June of 2019 and had actually copied, whited them out, and provided them to the carrier all the way back to January. That would have covered both the first and the second period of temporary partial disability. Keep in mind that during this entire period of time following her resignation, she was still reporting to the employer carrier's physician. They were still providing the required forms to the employer and the carrier, indicating that she was still under restrictions. The fact that their carrier chose not to send any forms to her until June of 2019 shouldn't work against my client. As to the appellee's other point, it doesn't really rhyme with what this court has decided. In one of Judge McCarr's cases in 2015, Hawkins versus Public Supermarkets, very similar set of facts. 440-15-4A was demonstrated to the JCC, but also the employee's refusal of suitable employment was found. And still in that case, the court found in the final order, the judge of compensation claims made no specific findings establishing the date of initial offer of employment, the dates of continued availability of a suitable job, the dates of the claimant's refusal, or whether the claimant's refusal continued after he was terminated from the employer. This is a part of that periodic analysis that the judge of compensation claims did not perform in this case. In the Moore case, very similar set of facts. Moore was terminated for cause because he just wouldn't show up for work. This court awarded him temporary partial disability benefits after he was terminated because the JCC found there continued to be a causal relationship between his injuries and his inability to work. So he was granted temporary partial disability benefits. In the case that we all speak of, MGM Electric versus Spencer, very same thing. The fact was, is Mr. Spencer, I'm sorry, I think this is Catherine. No, this is William Spencer. The employer terminated Mr. Spencer for cause, and this court also awarded temporary partial disability benefits after the employer-employee relationship was severed. So the argument that if you resign or are terminated, then we have no more responsibility, that's not the state of the law here. If that was the case, we just fire every claimant. Then we have no temporary partial disability eligibility, and we don't have to worry about it anymore. That's not what the law says, and that's not what this court has decided in past cases. What this court has said is the claimant has the burden to prove that they were injured on the job, and as a result of those injuries, they received medical restrictions that prevent them from earning the same income they did before they got hurt.
And that's where I'm still having a hard time seeing. I mean, and maybe you can answer the question of can we affirm on a basis that wasn't argued by the appellee? But I'm sorry, I'm having a hard time seeing anything in the record that makes that connection, other than it's a statement in the final order that the judge says he finds there's a connection, but I don't see where that is, and based on your client's testimony at the hearing.
Judge, there were medical records contained within the record on appeal and the record at trial that confirmed that there continue to be medical restrictions for the claimant all the way through December of 2019. Those medical records support her position that she was unable to work in her previous job based upon what was required of her as a certified nursing assistant versus what the treating neurosurgeon said her physical capabilities were. That's the causal connection.
But she had a job there and she was working, and she left it to go do something else. And, it's just unfortunate that she then got terminated from that job or left that job. And then additionally unfortunate that she was having a hard time finding other work, which you indicated that she wasn't given. There were no offers that she turned down because she was unable to perform those duties. She just didn't get any job offers. But there's no connection between that lack of job offer and her restrictions.
Well, Your Honor, I think that the fact that she continued to have medical restrictions and that those prevented her from seeking employment that she could have otherwise done had she not been injured is the difference between the facts. Is we proved that even until December of 2019, prior to her surgery, that she wasn't able to do her previous job. I mean, both in Moore and in MJM Electric, you had periods of time that this court analyzed where it was found that the claimant had zero income. The establishment of the causal connection, I give you that there was not a lot of argument on that, but it was because that neither party really argued that point at trial or on.
But by that logic, she would have been eligible for TPD when she was still at Summit, because she wasn't doing what she was originally trained to do. She wasn't working as a CNA anymore. She was doing other stuff which she didn't like doing. But if your logic is that she's only not eligible for TPD or not eligible for TPD if she's working in her original position, then I don't understand why you were saying that she was not eligible for TPD when she was still at Summit Ridge.
She wasn't eligible for TPD while she was still at Sandy Ridge because her income did not drop below the 80% threshold that's required by 440-15-4. That's the threshold.
But she wasn't working as a CNA while she was there.
Yes, sir, she was. She continued to work as a CNA. She just wasn't doing full CNA duties, but she was her job title didn't change. They just gave her, in fact, the employer carriers only witnessed Ms. Hodges, who was the manager or administrator, provided staffing sheets. And that was the other thing that I wanted to bring up. The employer carriers only witness in this was the administrator.
Counsel, you're almost 2 minutes over your time.
Oh, I'm sorry, Judge.
That's okay.
It's my fault. It's my fault.
It's okay. And I'm always going to allow a judge to ask questions, and I'll give you 15 seconds to sum up, counsel.
Your Honor, that completes my argument. Thank you for your time, and you stay safe and healthy. Thank you, sir.
Thank you both for your excellent arguments. The court is in recess.